meeting may be filmed or audio recorded. These records, including our meeting minutes, may be made available to the public. Good afternoon, everyone. We're here to decide the outcome of Senator Pelton's censure petition against ACCENT Chairman Sam Hendler, who this has compelled an investigation from the Joint Committee of the Rules and Ethics Committee and the Judiciary Committee. We're going to start with attendance. Can we just go ahead? You're going to state your name for the record, and then we'll start with you, Marianne.
Marianne Enriquez.
Andrew Savadash.
Lauren Jane Bryan.
Jonathan Bedeen.
Aaliyah Hendler. Julia Cyphers.
Smith Kingar.
Aaron Rubai.
Catherine Isaacson. Nicole Giamatti. Elizabeth Inswasti. Vivian Fallon.
Sam Hendler. Nathaniel Pelton.
And will all others in the room also state your name for the record?
Alexander Peterson.
Anna Hubert.
Raj Mia.
Tyler Scott.
Annie Wong.
Ronan Lupia.
Lucas Nadell.
Freddie Rappaport.
Alright. So before we start this meeting, there is no set procedure outlined in the code, so we're going to go ahead and discuss and outline for the hearing. How much time we want to give you guys? At this point, it's going to be a decision made by the committee. So we're going to go ahead and start with suggestions, and we're going to debate on how we want to do that one, and then we're going to go ahead and go to a vote. Please wait to be recognized, and go ahead and raise your hand if you want to speak, and I'll recognize you. And anyone?
I nominate Samantha Kingard as chair of the joint committee.
Do I hear any other nominations? Do I hear a motion?
Move to close the floor for nominations. I move to approve Samantha Kingard as chairman of this joint committee.
Are there any objections? Hearing none, that motion passes. Sorry, I forgot we had to do that. Alright, so do I hear any suggestions for how we want to do the procedure, how we want to outline the hearing?
Okay, so I have some suggestions. First of all, I move that the order of time periods be such that it is an opening statement first from the what's the correct word? Petitioner, followed by an opening statement from the defendant, testimony from the petitioner, and then testimony from the defendant. Then a Q&A period for the petitioner, Q&A period for the defendant, a closing statement from the petitioner and then from the defendant, and then 15 minutes, and then and then the deliberation period for the committee by unanimous consent.
Do you hear any objections? Hearing none, that motion passes. Also for the record, Connor Ruffin has entered the room. Attendance has changed. Alrighty, so I'm gonna go ahead and start.
Okay.
Wait, go
We
ahead.
have to make the time.
Yeah, go ahead.
Okay. My personal privilege manages the committee. Okay, so what I was thinking was roughly an hour per hearing. So this would go, what I've determined so far, this is up for debate, would be a 2-minute opening statement, a 10-minute testimony, 10-minute Q&A, 2-minute closing statement, and then 15 minutes of deliberations. If there are any other suggestions, I'd love to hear them. I think that's pretty fair. It's around an hour and 3 minutes per at the maximum. Because plenty of time for testimony and Q&A, which I both think should have a decent amount of time.
I have a question. What does testimony comprise of?
That would be either the petitioner or the defendant just speaking about their side of the case, not necessarily in the style of an opening or closing statement,
Okay.
which is in law, asking essentially the jury to go one way or another, but it's rather just to explain their case.
Okay.
Would you like to point out that?
What? Oh, I'm gonna wait for that. Go ahead.
Okay, yeah, but that's pretty much it. They just get to say their side of the case during testimony. There would be no questions and answers during the testimony because we made a period for it directly after.
Right, okay. I'll make a motion.
Yep. I move to have the aforementioned time frame be adopted by the committee by unanimous consent.
Do you hear any objections? Hearing none, that motion passes. Seeing that we have picked an outline and put it out, the way it's going to work outline for the hearing is going to be, we're going to hear from the petitioner, Senator Pelton. You're going to give your opening statement. You're going to have 2 minutes. Then ACCENT Chairman Hendler, you'll have 2 minutes as well, and you're following Senator Pelton. Then you're each going to give your testimony. Senator Pelton, you'll start with 10 minutes. Then ACCENT Chairman Hendler, you'll follow with 10 minutes. Then also, I just want to point out, during this period of testimony, we will not be taking questions. They're going to go uninterrupted. We have a designated Q&A time, so just keep your questions until then. Then we're going to be following with the 10 minutes of Q&A for starting with the petitioner, then with the defendant. When we do that, I will be calling on you individually, so you'll go ahead and raise your hand and wait to be acknowledged. And then we'll have 2 minutes for closing statements, starting with the petitioner and then the defendant. And then the Rules and Ethics Committee and the Judiciary Committee will deliberate. Following deliberations, the committee will conclude one of two things. If the committee deems that the charges presented are well-founded, or the committee shall report to the Senate a resolution calling for the defendant's censure or expulsion, or if the committee deems the charges to be not well-founded, the committee shall recommend to the Senate that the defendant be exonerated. You're each going to be given equal amount of time to speak in aspects. I will not be tolerating speaking out of turn. You're going to wait your turn. Seeing that there was no evidence submitted, when you cannot use any outside documentation in this. That includes in your testimony, when you're answering Q&A, opening statements, closing statements. The only things that can be used was anything mentioned in the censure petition. Got it? Alrighty. Also, all committee members, you're allowed to have one blank page open for notes. Therefore, there's no need for you guys to share your screens. I'll be monitoring and timing each segment of this meeting. Before we begin, though, I'm going to be giving you guys an oath. S.B.S. Come to you. Everyone have your right hand on here and then your
Sure.
wait, is it the right hand? Raise your right hand. Okay, guys. Alright, do you solemnly swear or affirm that the information you're about to give to this body is the full and complete truth?
I do.
Do you solemnly swear or affirm that the information you're about to give to this body is the full and complete truth?
Can I ask a question before we begin? Yeah, so just to clarify, as far as presentation goes, so long as everything directly correlates to the actual petition itself, any citations that were provided in the actual, we're good to go with that?
Yes.
Okay, just want to make sure.
You're gonna have 2 minutes, and we'll start when you begin speaking. Senator Pelton, whenever you're ready.
All right, good afternoon. I'm Nathaniel Pelton, off-campus senator and plaintiff in this case. First, I'd like to thank all members of the Student Senate's Joint Committee between the Rules and Ethics and Judiciary for meeting today and for convening to hear this petition. Today I stand before the Joint Committee to present the censure of ACCENT Speakers Bureau Agency Head Samuel Hendler. The censure petition, entitled Resolution to Censure ACCENT Agency Head Samuel Hendler, is what this committee shall consider in this hearing. This resolution is authored by Deputy Minority Party Leader Max Bannock, Senator Anna Huber, and myself, with sponsorship from Senators Jackson Ranson, Adriana Sella, Jasil Bijou, Ronan Hart, Daniel Permain, Isha Khan, Arturo Sarate, Marjan Khan, Alan Rivera Jaramillo, Erica Hardin, Arshan Falasiri, Caleb Goldstein, Fahim Islam, Megan Lamy, and Sarah Hoffer. The foundation of this censure rests upon 4 core points, all of which I will disseminate in the presentation. Number 1, Cornell Nellie Earl Haynes Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude were committed by the individual. Number 2, Samuel Hendler, in his position as executive agency head, pursued and entered into a contract with Cornell Nellie Earl Haynes Jr. in advance of an evening with Nellie, featuring a musical and speaking performance in violation of Student Body Statute 221.7. And finally, Samuel Hendler, executive agency head, for their involvement in violating Student Body Statute 221.7, shall be censured in accordance with Student Body Statutes 305.1, 305.2, and 305.7 for malfeasance of their duties as executive agency head. In totality of these points will make it clear that the censuring of Samuel Hendler is necessary and justified. Thank you.
All right, thank you, Senator Pelton. Chairman Hendler, you now have 2 minutes to speak.
Good afternoon, everyone. Thank you for taking the time to be here today. My name is Samuel Hendler, and I have been involved in ACCENT for 4 years, and I'm this year's ACCENT chair. Before I start today, I want to make it explicitly clear, and this should not be twisted in any way possible, that I understand the gravity of this situation, and I wholeheartedly condemn all forms of sexual abuse. I will work today to demonstrate to this committee that myself and my staff did our outlined procedure when procuring the talent for this ACCENT show. While I contend that myself and my staff did no deed worthy of censure, I do want to apologize to any student that felt hurt by the selection of Nellie as a featured artist. It goes without saying that ACCENT's purpose is to uplift and entertain students through a variety of guest speakers not isolate or create discomfort. Throughout today's hearing, I will continuously prove to you that it was not until after the official announcement of the event that I was made aware of any kind of allegations against Nelly. Had I known, I would have absolutely taken the necessary steps to ensure that these actions are not represented at the University of Florida by our performers. It was never my intent to bring in talent that would in any way cause harm to the student body at large. In my term, I've been proud to bring a strong series of speakers from a sold-out show with author John Green to the most recent incredible and brilliant female astronaut and Dr. Peggy Whitson. My team has kept the students we aim to serve constantly at the forefront of all of our decisions. I have continuously acted responsibly and always with the student body's best interest in mind. It has been nothing short of a wonderful experience to fulfill this role and keep ACCENT an uplifting and inspiring subset of the student government experience. Based on these reasons, I implore you all to acknowledge that I acted in genuine good faith. Thank you.
Thank you, Mr. Hendler. You're now going to go ahead and move into testimony. You'll each have 10 minutes. Senator Pelton, when you're ready.
All right. All right, so once again, as I stated previously, the foundation of the censure rests upon four core points, and once again, I'm going to repeat them. Number one, Cornell Haynes Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, among others, were committed by the individual. Number two, Samuel Hendler, in his position as executive agency head of the ACCENT Speakers Bureau, pursued and entered into a contract with Cornell Haynes Jr. in advance of an evening with Nelly featuring musical and speaking performance in violation of Student Body Statute 221.7. And finally, number three, Samuel Hendler, executive agency head for the ACCENT Speakers Bureau, should, for their involvement in violating Student Body Statute 221.7, be censured in accordance with Student Body Statutes 301.5, 305.2, 307.2 for malfeasance of their duties as executive agency head. First, as stated previously, Cornell Haynes Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, among others, were committed by the individual. This is the case for 6 core reasons. Number one, police investigative findings and arrest. An Auburn, Washington police investigation found probable cause of an assault by Cornell Haynes Jr. against Monique Green, a 22-year-old student at the University of Washington in the year of 2017. This investigation indicates severe allegations of sexual assault against Nelly. Number two, civil suit testimonies. A civil suit filed by Monique Green included testimonies of 2 anonymous women who alleged that Nelly sexually assaulted them in separate incidents. These testimonies corroborate the seriousness of the allegations and suggest a pattern of behavior. Number 3, settlement in civil suit. On September 27, 2018, a settlement was reached in the civil suit between Monique Green and Cornell Haynes Jr. in the King County Superior Court of the state of Washington, indicating the acknowledgement of wrongdoing or harm caused to the victim. Number 4, prosecutor's statement. In a statement released by the King County, Washington prosecutor's office, Green declined to cooperate with his prosecutors because she felt she could not, and quote, felt she could not stand up against a celebrity and that the criminal system would fail her. Number 5, Kohler's statement. Green's lawyer, Karen Kohler, in a statement released to local media following the settlement, in response to why Green decided to drop the cases against Haynes Jr., stated, "We do not live, quote, we do not live in a society where a 21-year-old college student can feel safe enough to pursue criminal charges against a celebrity for an alleged rape." She further stated, "As she cries alone in her apartment with mounting hysteria, she will learn that the celebrity and his lawyer are issuing public statements that her allegation is devoid of credibility and is motivated by greed and vindictiveness, and that her agenda is money, fame, and notoriety." Finally, 6, the overall pattern of behavior. When considering the totality of evidence, including the police investigation, civil suit testimony, settlement, prosecutor's statement, and media coverage, it becomes clear that there is reasonably compelling evidence to assume that Cornell Nelly Errol Haynes Jr. has been involved in acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude. These allegations are serious and raise concerns about the character and behavior of Nelly. In light of these points, it is reasonable to conclude that there is substantial evidence to support the assertion that Nelly is engaged in the specified acts outlined in Student Body Statute 221.2. 2, Samuel Hendler, in his position as executive agency head for the ACCENT Speakers Bureau, executive agency pursued and entered into a contract with Haynes Jr. in advance of an evening with Nelly featuring a musical and speaking performance in violation of Student Body Statute 221.7. This is the case for 3 reasons. Number 1, the SAINT Act and Student Body Statute 221.7 On October 1st, 2023, the Student Senate of the University of Florida passed Student Senate Bill 2023-1110, the SGP and Accent Integrity, Negotiation, and Transparency SAINT Act, authored by Judiciary Chairperson Jonathan C. Stevens and Senator Raj Mia, sponsored by Senator Antonio Hendricks, Majority Party Leader Simone Liang, and Minority Party Leader Bronson Alaman. SSB 2023-1110 passed by unanimous consent in both readings before the Student Senate. Student Body Statute 221 states, Accent Speakers Bureau shall not pursue or enter into a contract with an organization or persons that have committed the following acts or have reasonably compelling evidence to assume that an act was committed. 1. Sexual assault. 2. Sexual misconduct. 3. Sexual harassment. 4. Sexual grooming. 5. Dating violence. 6. Indecent exposure. 7. Sexual exposure to minors. 8. Moral turpitude as defined by 307.2, Section 14 of the Student Body Statutes. Number 2, Accent Speakers Bureau entered into a contract with Haynes Jr. for An Evening with Nellie, featuring a musical and speaking performance. On March 31st, 2024, Accent Speakers Bureau announced An Evening with Nellie, featuring a musical and speaking performance with Cornell Nellie Errol Haynes Jr. Student Body Statute 221.2 states, Accent Speakers Bureau shall exist as an agency of student government in order to provide a well-balanced variety of free and paid entertainment through the academic year. Accent Speakers Bureau shall be the sole student government-funded agency for booking youth-oriented contemporary entertainment and shall coordinate all contractual, financial, promotional, and production details for these productions. This code makes it clear that Accent Speakers Bureau is the sole agency responsible for booking youth-oriented contemporary entertainment, including the coordination of all contractual, financial, promotional, and production details for the productions. It is clear, based on these responsibilities, that the Student Government Productions was responsible for, that Accent Speakers was responsible for contracting Haynes Jr. for An Evening with Nellie, featuring musical and speaking performance. Third and finally, Samuel Hendler, Accent Speakers Bureau Executive Agency Head, was responsible for pursuing and negotiating the contract with Haynes Jr. for An Evening with Nellie, featuring a musical and speaking performance. Student Body Statute 221.3 states, quote, there shall be an Accent Speakers Bureau chairperson who shall be responsible for scheduling entertainment, negotiating contracts, formulating a budget, and overseeing all other activities of Accent Speakers Bureau. Samuel Hendler, in the capacity of Accent Speaker Bureau's agency head, was statutorily responsible for pursuing the contract with Haynes Jr. under Chapter 220 of Student Body Statutes. A contract was pursued and executed through Accent Speakers Bureau with Haynes Jr. for the event. Third and finally, Samuel Hendler, Executive Agency Head for Accent Speakers Bureau, for their involvement in violating Student Body Statute 221.7 shall be censured in accordance with Student Body Statutes 305.1, 305.2, 307.2 for malfeasance of their duties as Executive Agency Head for the Accent Speakers Bureau. Student Body Statute 305.1 states censure is defined as a resolution passed by the Student Senate in lieu of impeachment. In effect, censure is a written reprimand given to an official whose actions may have warranted impeachment, but the Student Body Senate felt impeachment was unnecessary. Furthermore, Student Body Statute 305.2 states offenses warranting censure include but are not limited to the following acts committed while in office: misfeasance, malfeasance, nonfeasance, and abuse of power. Finally, Student Body Statute 307.2 defines malfeasance as doing an act that is wholly wrongful as per Blackwell's Dictionary. Blackwell's Dictionary further defines malfeasance as the wrongful or unjust doing of some act which the doer has no right to perform or which he has stipulated by contract not to do. Samuel Hendler, in the position of Executive Agency Head of the Accent Speakers Bureau Agency, committed a wrongful act which he has stipulated by contract not to do. The Student Body Statutes serve as a contract between the Student Senate, the Student Body, and the Student Body that elected them, and finally the Executive Branch, to ensure checks and balances over executive power and to regulate the actions of the University of Florida student government. Samuel Hendler wrongfully broke this contract, specifically Student Body Statute 221.7, when he entered into a contract with an individual, Haynes Jr., who had reasonable evidence to conclude the assertion that he was engaged in specified acts prohibited by the contract in Student Body Statute 221.2 and Student Body Statute 221.3. I'd finally like to point out that in the opening statement of the defendant, it has been already dished up to the committee that the act and the statutes were violated. Instead, simply, rather than face the consequences of that act, it has been determined by the defendant that instead they will fall behind the excuse that they did not do the research in time and did not know that Nellie had these allegations against them in advance. two core reasons why that is flawed and why you must consider the argument that I just gave you rather than exonerating this individual. Number one, you can discover that this individual has allegations from a simple Google search. It is the responsibility of the ACCENT Speakers Bureau and its $500,000 annual budget to make sure that the individuals it brings in, as per the Student Body Statutes, are the utmost representatives of the student body and of not engaging these acts. And it's very simple to discover that these acts were committed. Number two, and more importantly, is the legal principle of the rule of law. It is a responsibility of every citizen of the United States, of the state of Florida, of Alachua County, and student at the University of Florida to understand the laws by which govern them. It is not the responsibility of the government to inform an individual of the laws that oversee them. It is all of our responsibility to do our due diligence and understand the laws that we may or may not break. And in this particular case, Samuel Hendler did not do the due diligence of following the law and instead broke it in the harm of the student body. The Joint Committee must respond to this wrongful act breakage of the contract between Student Senate and of the University of Florida by doing its duty and issuing a censure against Samuel Hendler for malfeasance on all of these grounds. And I yield the remainder of time.
Thank you, Senator Pelton. Chairman Hendler, you'll have 10 minutes for everything.
So just to start, probably not going to take all 10 minutes. I'm just going to kind of guide you guys through the process of how our organization works and how we book speakers and all that. So first and foremost, due to the same act, we have put out our semesterly surveys to gauge what kind of speakers that the student body wants us to bring in. We did that, and we value the feedback of the student body, and we did indeed use their feedback to have this last show. From there, it is indeed a collaborative effort where we work with middle party agents who work with the prospective talent, and then from there, that's where the talent review process gathers info about prior shows and events that the prospective talent has engaged in previously. From there, we have discussions with advisors, and then the contract offer letters go out, as well as contracts and other legal language are drawn up by the advisors who take care of that. During this specific show with Nellie, I genuinely cannot recall any issues that arose on the first level of review. I was also unaware that it was under the job description for the chair, and it is not directly specified in the statutes to conduct legal background checks as chair, as I was under the assumption that there were other individuals who focused on these components of the holistic review. Other than that, once a contract is agreed upon, I help with the logistics of the venue, working with their staff, making sure that everything is good on their end. I book the security for the event with UPD, staffing for the event with my staff. I have close to 50 staff members that I'm in charge of, and I love working with them, and they do a great job with promotion and really being there when we need them to be, and just other comparable tasks like that. But yeah, that's pretty much the entire process of how it works for my position. I'm sure Student Government Productions, Luke can talk on for his behalf, but as far as ACCENT, that's how we manage our business. So I need the rest of the time.
Thank you, Mr. Hendler. We're going to go ahead and move into the question and answer period. The first question and answer period is going to be for Senator Pelton. You'll have 10 minutes. Please raise your hand if you have a question and wait till I acknowledge you to ask. Any questions?
Just really quickly, I want to ask what you believe constitutes reasonably compelling evidence, as stated in the rule that you brought up. Do you believe that settlements from court cases constitute reasonably compelling evidence?
So actually what I would suggest meets more than even the settlements, the confines of reasonably assumed evidence, is the fact that there were officers found probable cause to arrest the individual in question. And so the actual issue here is not necessarily just that there were settlements, but that, for one, there were accusations. Number two, that they were credible enough to reach probable cause by the, I believe, I can't remember the county, but within Seattle, to arrest the individual. And then, of course, the multiple settlements that expand multiple years with victims. Yes, I do believe that all of those in collaboration, not just the settlement, do meet that qualification.
Any other questions? No? We're going to start our second question and answer period. These questions are going to be directed towards Chairman Hendler. And if you have any questions, you can go ahead and raise your hand.
I'd like to know why, in particular, you selected Nelly to be at this show in particular.
Yeah, sure. So as far as this specific show, this is definitely a very unique show. As you guys know, ACCENT is predominantly, traditionally, just normal speaking engagement shows. But ACCENT and SGP both thought that it would be kind of a unique perspective to engage the students with both a speaking and a performance. So that is why we wanted to try and find something that would fit that criteria. As far as specifically Nelly, before that we had a list of speakers that we went through, and some of the speakers we weren't able to come to an agreement just based on they weren't able to make it due to a conflict on that day, or they were not comfortable doing that type of performance with the speaking component as well. And I also want to bring up that one of the individuals that was on our list, we did find that he did have some type of legal history. That was a concern, and immediately we ended that and we continued to move on into the cycle. But with Nelly, we worked with the middle party agent, like I discussed earlier. He told us about his prior shows. He had 4 sold out shows at other colleges. And that's pretty much, and he was willing to do both the speaking and the performance, so that's pretty much how we ended up with Nelly.
I saw your hand first.
Chairman Hendler, you said that there's a holistic review of the talent that comes before ACCENT. Can you talk a little bit more about that and how, as you just previously mentioned, that there are people that have shown a legal background that is dubious to have them go further in the process? Do you think that somehow there was a slip in the system?
So as far as the review, like I mentioned, that we work with the agent that provides the talent for us. He gives us the list of names that we can kind of look through and discuss as a collective group. From there, that's when there's multiple parties involved that we're supposed to do background checks and look at other review. But as far as Nelly, we did not find anything on the first level that rose to a concern.
Thank you.
Okay. So, just to make it clear, were you aware of the accusations with Nelly before you entered into the contract with him?
Absolutely not.
Okay. I have a follow-up question.
Sure.
If you had known about the allegations earlier, would you have entered into that contract with Nelly?
Absolutely not.
Okay.
Any more questions? No? Alrighty, now we're gonna move into our closing statements. We each have 2 minutes, and Senator Pelton, you can begin whenever you're ready.
All right, once again, we are here to determine whether this individual has the right or should be censured on malfeasance. I want to once again define the word malfeasance, which is the wrongful or unjust doing of some act which the doer has no right to perform or which he is stipulated by the contract not to do. I am very glad that the defendant has admitted that doing this was wrong, but they've also admitted to several other things. They admitted to breaking the same act by bringing Nelly. They admitted to following the SAINT Act at a later time when they were going through and doing the surveys. So how can they understand how the SAINT Act works and then violate the same laws when it comes to Nellie? Next, they also stated that they found someone else on the list of possible people who had broken the law previously and that they struck them off the list because of the SAINT Act. And finally, they stated that multiple individuals, multiple parties were involved with the process to determine whether Nellie had violated any law under Student Body Statute 221.7. Once again, there is a clear negligence to do wrongdoing in this case. There is a legal principle, once again, that is extremely important in this country and in this state, the rule of law. It runs everything that we do. In this particular case, it was the responsibility of Hendler to do the due diligence of finding that Nellie had multiple accusations in violation of the SAINT Act before signing a contract with him. He has admitted on multiple occasions that he did not do that due diligence, that he failed to do that due diligence, that other parties failed to do that due diligence, and that overall, he wouldn't have brought Nellie in the first place if he did go back. It's not our job to have sympathy for someone who does wrong. It's our job to correct the actions when we see that violations have occurred, and setting a precedence that this cannot occur again. And that is why I'm asking all of you to move this censure forward to the full Senate floor and find cause that malfeasance has occurred. Thank you.
Thank you, Senator Pelton, and Chairman Hendler, whenever you're ready.
Just to wrap up, again, I want to reiterate the seriousness and the gravity of this situation. And as I said under oath, I genuinely had no idea of any allegations until after the announcement of the show, which was on social media. Like I said, if these allegations were presented to me, I would have ensured that these values were not represented at the university for our student body. Additionally, one last thing, I just want to touch on that the language in the SAINT Act is too vague and ambiguous, and if UF Senate, in their eyes, ultimately decides that the accused individuals fall under reasonably compelling evidence, then it needs to be amended to make it more clear and enforceable for individuals who hold these positions in the future.
Thank you, Chairman Hendler. First, for the record, I just want to say attendance has changed and Victoria Peters has entered the room. Now it's time for deliberations. I just want to make clear committee members are the only ones with speaking privileges in this room. If you're not on the committee, just please don't speak. With that, you guys will have 15 minutes to discuss and you're free to discuss amongst yourselves whenever you are ready. You don't have to raise your hand for this. You can just speak.
Yeah, we have 15 minutes. Quite a bit of time. Okay, so I think the main key components that we have to consider here are the statute itself, which in this case, the most prudent part of that statement is reasonably compelling evidence to assume that such acts were committed. So we have to talk about this. We also have to talk about there are actually two charges in this, not just malfeasance. It's malfeasance and nonfeasance. There is a difference between the two. Nonfeasance is a failure to act. Essentially when you don't do something completely, it's essentially negligence, which is a word that I was hearing frequently during the speeches given, both especially by Senator Pelton, versus malfeasance, which indicates an intentionality. It's something that you go into, that you're breaking the codes knowingly, and that the breach of the codes is not by accident, and it is not from negligence, but rather it's from knowing that would cause harm, A, that it was cause harm to the student body, and B, that you knew you were violating the codes to begin with. So what I have to say is, I think based on the testimony we've heard today, that there was an element of negligence. I don't want to put, I feel as if it isn't totally specified in the codes that this is all ACCENT's job to do the background screening, but I do think it's reasonable to assume, and in the future this has to be codified by Senate, that there has to be some sort of procedure for background checks in this regard, because I think it wasn't just ACCENT, it was this third-party agent and whoever else is part of this background screening process. That clearly needs to be amended, but for this case, I do think that there was an element of negligence that led to the booking of someone who led to the censure, frankly. As for the statement in the codes, this is where I have a little bit of an issue. This says reasonably compelling evidence to assume that such acts were committed. The problem I have with the codes is that this applies to the ACCENT and SGP chairs, who are not lawyers, who are not judges, and do not, frankly, have the ability to determine what constitutes reasonably compelling evidence. There could be different definitions for this, and I would urge the committee to be really careful about what we constitute as reasonably compelling evidence. Allegations or accusations is a line that could be drawn, so as same way that probable cause could be drawn. But I will caution the committee in saying that it is close to an infringement upon due process itself if we get to the point where people who are not convicted of the crimes of which they were accused, and we are essentially assuming through a preponderance of the evidence by a group that are not lawyers and are not judges and are not a jury, that this act was committed. So in my opinion, the lack of knowledge about the background and these allegations against Nellie would constitute nonfeasance. I do think that there was a lack of research into the background, not entirely at the fault of ACCENT or SGP, but I do think that someone has to be accountable for that, and it needs to be increased in the future, so we're more diligent about the things that are in the backgrounds of these individuals. What I would say is that I'm very strongly against the use of malfeasance here. There's a lack of intent, purely by not knowing that there were allegations against Nellie, means that malfeasance didn't occur here. Negligence is a possibility, but malfeasance most certainly did not. So in my opinion, this censure should have the malfeasance charge stricken and should keep the nonfeasance charge, as I believe that is appropriate. And that is all I have to say for this.
Really quick, just for the record, I just want to say attendance has changed and I'm not Nathaniel is into the room. Sorry, you can continue. You don't have to return.
Oh, okay. Yeah, I want to echo that sentiment made by Judiciary Chair Revi. I think that nonfeasance is probably a better way to put this rather than malfeasance. It sounds like Senator Pelton has determined that the reasonably compelling evidence that we have within this case is that there was probable cause that came from the accusation that led to the arrest. But, you know, sexual assault generally is not a good thing. We condemn anything related to sexual assault. Horrified to see that there was a performer with a sexual assault accusation or charge. But while I don't agree with the decision to necessarily bring in a person with those charges, I don't necessarily think that the burden should fall on ACCENT and SGP chairs now and in the future to essentially determine whether someone has reasonable evidence or not against them for sexual assault. This is a due process issue, but Senator Pelton did define what the reasonably compelling evidence was for us, so I think that moving forward in the future, this should be a heads up to us that the STATE Act as written is unfair. It could set some type of immoral precedence from a legal standpoint because the codes should be written clearly and definitively. So this is something that we can identify and go in ASAP and change to make as crystal clear as possible. So something like this doesn't happen again, and it's not up to the chairs to determine what constitutes reasonable evidence.
I would like to echo Majority Leader and Judiciary Chairman had to say is that malfeasance is the willful ignorance of the law. From Chairman's own words, I don't believe Chairman Hendler was being willfully ignorant of the SANE Act. Moreover, I don't think it was an immoral reasoning to decide, let's go ahead with this particular individual, regardless of the issues. I believe that he was unaware of the issues, and that ultimately there is some culpability there. But I don't believe that the individual accused was someone who's committing the act of nonfeasance, perhaps.
Sorry, I just wanted to comment on what Senator Censure, said about the SANE Act. I would just personally and respectfully disagree in the sense that I think that any accusation, allegation, charge, or involvement with sexual assault cases, I feel like does not paint a good image on any speaker that we decide to go into a contract with, whether it's still up in the air, whether it's eventually, let's say hypothetically the charges fall through or they don't actually go through. I think during that period of uncertainty, it would just be a wiser choice on the university's part to just not go into a contract, just to be on the safer side. So I think that the wording of the SANE Act isn't necessarily immoral in that sense by saying sexual assault broadly, because I think the point is to just avoid speakers that are involved in that at all.
Yes, I wholeheartedly agree with that. To address, I wasn't trying to say that the issue was with like the definition of sexual assault itself. I'm going to read the exact statute. It states, student government productions shall not pursue or enter into a contract with an organization or persons that have committed the following acts or have reasonably compelling evidence to assume that an act was committed. And then it lists like the number of bullet points of the different sexual assault, misconduct, all that. So what I was more so saying is that reasonably compelling evidence is kind of an ambiguous term that for the SAFE Act to have the most use possible and to do the most good possible, we should definitely be defining something like this in the codes.
Yeah, I want to point out that it would be, like, the reason it has to be specified so clearly, we have to draw a line at some point in the sand where we do not allow speakers or performers to come and enter into contracts if they have gone through a certain step in the legal process. The problem with the code as written is that it states with reasonably compelling evidence, basically, where's the first part of that code? Basically, it's saying that this is, in my understanding of how, as it reads now, is reasonably compelling evidence of guilt. So essentially, we're asking two undergraduate students to determine the guilt of a person who is not found guilty in a court of law. This is a problem. Now, I don't think it would be an issue if we were to draw a line anywhere along this grade, whether it's from pending accusations or to arrest or whatever the line is. My issue is that they cannot be expected to decide this for themselves, that they aren't equipped with the legal understanding or, frankly, the authority to determine someone's guilt in the manner that this code is prescribing. So I think it would be an undue burden and morally wrong to assume that they have the same powers as the criminal justice system and that they can determine guilt. Therefore, I think that as the evidence is stated here, I agree that there could have been a more thorough, in-depth research into the background of Nellie. And I think everyone here thinks that that should have been done, including the petitioner, the committee, and the chairman. But I do think because of the vagueness of the codes and because it could have been interpreted in a way that the contract was made with the person who didn't have reasonably compelling evidence, because this is up for debate. I mean, we're at a committee right now debating whether or not this is reasonably compelling. We can't force this type of code on someone who is unilaterally making that decision just for us to come in later and say, oh, you made the wrong decision. That's a problem. We have to set up a strict guideline so that we don't enter into contracts in the future with people who have either allegations or a conviction or anything. But it just has to be very clear. So as for the censure itself, because I think there could have been more research into the background of Nellie, I do think that nonfeasance is applicable. Negligence to discover this fact may not be entirely on accent, but part of it is. Whether that has to be defined in the future is up to us, but it has to go onto several parties, and I believe that one of them is accent. So I think nonfeasance would be applicable, but malfeasance for a code that we're debating right now, we can't expect them to make a unilateral decision. that they are within the codes and then punish them later. So that's my opinion on this resolution.
We have 3 minutes left. You're free to speak.
Oh, okay. In terms of the reasonably compelling evidence, I think Acting Chair Hendler was saying that in the previous case of like a different person they were gonna bring in though, he understood that they had some allegations where like there was something that was brought up that made him not go or made Acton not go through with that. So I think since they made that decision based off the same act, they had a good understanding of what that code means. And so I think it was a matter of just not going through the thorough process of the background checks with Nelly too. But I don't think it's a matter of like not understanding the code because I think they had their interpretation of that if they were able to make that decision based off of this code. So I don't know, maybe that could be something we could consider.
So I will say that I don't know what the background of the other person.
I'm sorry, only committee. If they're free to speak, any committee member is free to speak.
I'll be quick. Basically, we don't know what the other person involved in this selection process was convicted with, charged with. If they were convicted, for example, then it's a much different interpretation on behalf of ACCENT. Because someone who is convicted of a crime would explicitly be banned from being entered into a contractual agreement with. Because this could vary from case to case based on if they were convicted, if they were charged, if they stood trial. I think that leeway per candidate means that even if they applied it correctly to another case, that our determination of what is correct in this case might not have been their initial interpretation, meaning they didn't willfully break the codes.
Sure. So I do want to mention that I know you were talking about the vagueness of the code, but I feel like from what I've come into and listened to, we shouldn't be debating the code as much as just whether or not this individual abided by it. If you go on Nelly's, I don't know if this has been mentioned yet, on Nelly's Wikipedia, there's literally a whole list of legal issues. Rape arrest, tax fraud, misdemeanor, drug offenses, like, it's on the Wikipedia page. So when you want to talk about compelling evidence, it's like literally, everything is out there. This is very obvious, and I do want to say that from what I've been, people have been catching me up on what I've been hearing, if there has been something in which another speaker or performer was kind of, background checked to a, so to speak, literally just looking up Nelly, clicking on the first Wikipedia link, you would find this. So I'm just not understanding why we're debating like some of the smaller nitty gritty when it's very obvious online what happened. And just clicking around, it seems like, just from a very preliminary search, whatever, it kind of seems like some of these things happened in very public places or on college campuses, just from what I'm clicking around and looking at. And I feel like that poses a very big problem and very obviously breaks the same act. And that's it.
That is time. Do I hear any motions?
I move to strike the therefore let it further be resolved clause that ends with for malfeasance in accordance with codes 305.1, 305.2, and 307.2 S.B.S. by unanimous consent.
Is there a motion to strike the aforementioned clause from this resolution by unanimous consent? Are there any objections?
Wait.
What clause?
The clause that specifies the charge of malfeasance.
The second to last, therefore let it be resolved clause.
Correct.
Thank you. Do I hear any objections?
I'm sorry, can you just repeat that?
The motion or the clause?
Second to last, therefore let it be resolved.
He wants to strike the whole one.
Do I hear any objections? Hearing none, that motion passes. Do I hear any more motion?
I move to recommend the, it's not numbered, but the resolution to censure ACCENT agency head Nathaniel Hendler to the floor of the Senate with the sole charge listed as being nonfeasance in accordance by unanimous consent.
Alright, so there's been a motion to recommend the resolution against Chairman Samuel Hendler with only the charge of nonfeasance to the Senate floor for unanimous consent. Are there any objections? Hearing none, that motion passes. Seeing that,
Did you want to strike?
it's already been
No,
said.
that's fine. That's it.
Seeing that this hearing's over, do you want to move into recess?
Sure, yeah, I move for recess to be called back by the chair by unanimous consent.
Any objections? Hearing none, that motion passes.
SGP one. Oh, shit, I didn't even know how the And collaboration. As an author at the same time, I have a lot of.
If I had to take notes on the deliberation. Okay. I did.
Okay, Jonathan's the one that handled the second part of that sentence. Because Josh Richardson, I thought I did that, just showed it as you take time.